Wyoming versus Houghton, Justice Scalia delivered the opinion of the court in 1999. In the early morning hours of July 23, 1995, a Wyoming Highway Patrol officer stopped an automobile for speeding and driving with a faulty brake light. There were 3 passengers in the front seat of the car: David Young, the driver, his girlfriend, and respondent. While questioning Young, the officer noticed a hypodermic syringe in Young's shirt pocket. He left the occupants under the supervision of 2 backup officers as he went to get gloves from his patrol car. Upon his return, he instructed Young to step out of the car and place his syringe on the hood. The officer then asked Young why he had a syringe. With refreshing candor, Young replied that he used it to take drugs. At this point, the backup officers ordered the 2 female passengers out of the car and asked them for identification. Respondent falsely identified herself as Sandra James and stated that she did not have any identification. Meanwhile, in light of Young's admission, the officer searched the passenger compartment of the car for contraband. On the back seat, he found a purse which respondent claimed as hers. He removed from the purse a wallet containing respondent's driver's license, identifying her properly as Sandra K. Houghton. When the officer asked her why she had lied about her name, she replied, "In case things went bad." Continuing his search of the purse, the officer found a brown pouch and a black wallet-type container. Respondent denied that the former was hers and claimed ignorance of how it came to be there. It was found to contain drug paraphernalia and a syringe with 60 cc's of methamphetamine. Respondent admitted ownership of the black container, which was also found to contain drug paraphernalia, and a syringe which respondent acknowledged was hers, with 10 cc's of methamphetamine, an amount insufficient to support a felony conviction at issue in this case. The officer also found fresh needle track marks on respondent's arms. He placed her under arrest. The state of Wyoming charged respondent with felony possession of methamphetamine and a liquid amount greater than 0.3 of a gram. After a hearing, the trial court denied her motion to suppress all evidence obtained from the purse as the fruit of a violation of the Fourth and 14th Amendments. The court held that the officer had probable cause to search the car for contraband, and by extension, the containers therein that could hold such contraband. A jury convicted respondent as charged. The Wyoming Supreme Court, by divided vote, reversed the conviction and held that the search of respondent's purse violated the 4th and 14th Amendments because the officer knew or should have known that the purse did not belong to the driver but to one of the passengers, and because here was no probable cause to search the passenger's personal effects and no reason the contraband had been placed within the purse. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. In determining whether a particular governmental action violates this provision, we inquire first whether the action was regarded as an unlawful search or seizure under the common law when the amendment was framed. Where that inquiry yields no answer, we must evaluate the search and seizure under traditional standards of reasonableness by assessing, on the one hand, the degree to which it intrudes upon the individual's privacy, and on the other, the degree to which it is needed for the promotion of legitimate governmental interests. It is uncontested in the present case that the police officers had probable cause to believe there were illegal drugs in the car. See Carroll versus United States. In 1925. Similarly, involved the warrantless search of a car that law enforcement officials had probable cause to believe contained contraband. In that case, bootleg liquor. The court concluded that the framers would have regarded such a search as reasonable in light of legislation enacted by Congress 1789 through 1799, as well as subsequent legislation from the founding era and beyond that empowered customs officials to search any ship or vessel without a warrant if they had probable cause to believe it contained goods subject to a duty. Thus, the court held that contraband goods concealed and illegally transported in an automobile or other vehicle may be searched for without a warrant, where probable cause exists. We have furthermore read the historical evidence to show that the framers would have regarded as reasonable, if there was probable cause, the warrantless search of containers within an automobile. In the United States, First Ross, 1982, we upheld as reasonable the warrantless search of a paper bag and leather pouch found in the trunk of a defendant's car by officers who had probable cause to believe the trunk contained drugs. Stevens, writing for the court, observed, "It is noteworthy that the early legislation on which the court relied in Carroll concerned the enforcement of laws imposing duties on imported merchandise. Presumably, such merchandise was shipped then in containers of various kinds, just as it is today. Since Congress had authorized warrantless searches of vessels and beasts for imported merchandise, it is inconceivable that it intended a customs officer to obtain a warrant for every package discovered during the search. Certainly, Congress intended customs officers to open shipping containers when necessary, and not merely to examine the exterior or cartons or boxes in which smuggled goods might be concealed. During virtually the entire history of our country, whether contraband was transported in a horse-drawn carriage, a 1921 roadster, or a modern automobile, it has been assumed that a lawful search of a vehicle would include a search of any container that might conceal the object of the search. Ross summarized its holding as follows. If a probable cause justifies the search of a lawfully stopped vehicle, it justifies the search of every part of the vehicle and its contents that may conceal the object of the search. Emphasis added. And our later cases describing Ross have characterized it as applying broadly to all containers within a car without qualification as to ownership. To be sure, there was no passenger in Ross, and it was not claimed that the package in the trunk belonged to anyone other than the driver. Even so, if the rule of law that Ross announced were limited to contents belonging to the driver or contents other than those belonging to passengers, one would have expected that substantial limitation to be expressed, and more importantly, one would have expected that limitation to be apparent in the historical evidence that formed the basis for Ross's holding. In fact, however, nothing in the statutes Ross relied upon or in the practice under the statutes would accept from authorized warrantless search packages belonging to passengers on the suspect ship, horse-drawn carriage, or automobile. Finally, we must observe that the analytical principle underlying the rule announced in Ross is fully consistent, as the respondent's proposal is not, with the balance of the Fourth Amendment jurisprudence. Ross concluded from the historical evidence that the permissible scope of a warrantless car search is defined by the object of the search and the places in which the probable cause there is probable cause to believe that it may be found. The same principle is reflected in an earlier case involving the constitutionality of a search warrant directed at premises belonging to one who was not suspected of any crime. The critical element in a reasonable search is not that the owner of the property is suspect of crime, but that there is reasonable cause to believe that specific things to be searched for and seized are located on the property to which entry is sought. Zurcher v. Stanford Daily in 1978. In sum, neither Ross itself nor the historical evidence it relied upon admits a distinction among packages or containers based on ownership. When there is probable cause to search for contraband in a car, It is reasonable for police officers, like custom officials in the founding era, to examine packages and containers without a showing of individualized probable cause for each one. A passenger's personal belongings, like the driver's belongings or containers attached to the car, like a glove compartment, are in the car, and the officer has probable cause for contraband in the car. Even if the historical evidence as described in Ross were thought to be equivocal, we would find that the balancing of the relative interests weighs decidedly in favor of allowing searches of a passenger's belongings. Passengers, no less than drivers, possess a reduced expectation of privacy with regard to the property that they transport in cars, which travel public thoroughfares, seldom serve as the repository of personal effects, are subjected to police stop and examination to enforce pervasive governmental controls as an everyday occurrence, and finally are exposed to traffic accidents that may render all their contents open to public scrutiny. In this regard, a degree of intrusiveness upon personal privacy and indeed even personal dignity, the two cases the Wyoming Supreme Court found dispositive, differ substantially from the package search at issue here. U.S. v. D. Ree, 1948, held that probable cause to search a car did not justify a body search of the passenger, and Ybarra v. Illinois, 1979, held that the search warrant for a tavern and its bartender did not permit body searches of all the bar's patrons. These cases turn on a unique, significantly heightened protection afforded against searches of one's person. Even a limited search of the outer clothing constitutes a severe, though brief, intrusion upon cherished personal security, and it must surely be an annoying, frightening, and perhaps humiliating experience. Terry v. Ohio, 1968. Such traumatic consequences are not to be expected when the police examine an item of personal property found in the car. Whereas the passenger's privacy expectations are, as we have described, considerably diminished. The governmental interests at stake are substantial. Effective law enforcement would be appreciably impaired without the ability to search passengers' personal belongings when there is reason to believe contraband or evidence of criminal wrongdoing is hidden in the car. In addition, as in all car search cases, the ready mobility of an automobile creates a risk that evidence or car passenger, unlike the unwitting tavern patron in Ybarra, will often be engaged in a common enterprise with the driver and have the same interest in concealing the fruits or the evidence of their wrongdoing. A criminal might be able to hide contraband in a passenger's belongings as readily as in other containers in the car, perhaps even serendipitously without the passenger's knowledge or permission. This last possibility provided the basis for respondent's defense at trial. She testified that most of the seized contraband must have been placed in her purse by her traveling companions or at one or another various times, including the time she was half asleep in the car. To be sure, these factors favored a search will not be present, but the balancing of interests must be conducted with an eye to the generality of cases, to require that the investigating officer have positive reason to believe that the passenger and driver were engaged in a common enterprise, a positive reason to believe that the driver had time and occasion to conceal the item in the passenger's belongings serendipitously or with friends' permission, is to impose requirements so seldom met by a passenger property rule would dramatically reduce the ability to find and seize contraband evidence of crime. Of course, these requirements would not attach under the Wyoming Supreme Court's rule until the police officer knows or has reason to know the container belongs to a passenger. But once a passenger's property exception to car searches became widely known, one would expect passenger Confederates to claim everything as their own. And one would expect a bog of litigation in the form of both civil lawsuits and motions to suppress and criminal cases involving such questions as whether the officer should have believed the passenger's claim of ownership, whether he should have inferred ownership from various objective factors, whether he had probable cause to believe that the passenger was a Confederate, or to believe that the driver might have introduced the contraband into the package with or without the passenger's knowledge. When balancing the competing interests, our determinations of reasonableness under Fourth Amendment must take account of these particular realities. We think they militate in favor of the needs of law enforcement and against the personal privacy interest that is ordinarily weak. So that's their test. Finally, if we were to invent an exception from the historical practice that Ross accurately described and summarized in its perplexing way, that exception should protect only property belonging to the passenger rather than what seems much more logical, property belonging to anyone other than the driver. Surely Houghton's privacy would have been invaded to the same degree whether she was present or absent when her purse was searched, and surely her presence in the car with the driver provided more rather than less reason to believe that the two were in league. It may ordinarily be easier to identify the property as belonging to someone other than the driver, when the purported owner is present to identify it. But in many cases, like Ross itself, where the car is seized, that identification may occur later at the station house or even at the site of the stop. One can readily imagine a package being marked with the owner's name and the phone number by which the officer can confirm the driver's denial of ownership. The sensible rule, and the one supported by history and case law, is that such a package may be searched whether or not the owner is present as a passenger or otherwise, because it may contain the contraband that the officer has reason to believe it is in the car. We hold that police officers with probable cause to search a car may inspect passengers' belongings found in the car and are capable of concealing the object of the search. The judgment of the Wyoming Supreme Court is reversed. There is a concurring opinion from Breyer, Stephen Satter Ginsburg dissent, and the whole thing is about 3 pages. Before I get into that, which I might not get into on this call, I'm looking at footnotes. There's a little bit more about United States d. Re, such as the holding. It is which held, as the dissent describes it, that the automobile exception to the warrant requirement did not justify searches of the passenger's pockets and the space between his shirt and underwear. It attributes that holding to the subtle distinction between drivers and etc. The new rule that is based on distinction between property became contained in clothing worn by a passenger and property contained in passenger's briefcase or purse. So about this concurrence, I join the court's opinion with the understanding that History is meant to inform, but not automatically to determine the answer to the Fourth Amendment question. I also agree with the court that when a police officer has probable cause to search a car, say, for drugs, it is reasonable for that officer also to search containers within the car. If the police must establish a container's ownership prior to the search of the container, whenever, for example, the passenger says, "That's mine," the resulting uncertainty will destroy the workability of the bright line rule set forth in U.S. v. Ross. At the same time, police officers will, with probable cause to search a car for drugs, would often have probable cause to search containers regardless. Hence, a bright line rule will authorize only a limited number of searches that the law would not otherwise justify. At the same time, I would point out certain limitations upon the scope of the bright line rule that the court describes. Obviously, the rule applies only to automobile searches. Equally obvious, the rule applies only to containers found within automobiles, and it does not extend to the search of a person found in that automobile. As the court notes, and as United States v. D. relied on heavily by Justice Stevens' dissent, makes clear, the search of a person, including a limited search of the outer clothing, is a very different matter in respect to which the law provides significantly heightened protection. Less obviously, in my view, also important is the fact that the container here at issue, a woman's purse, was found at a considerable distance from its owner, who did not claim ownership until the officer discovered her identification while looking through it. Purses are special containers. They are repositories of especially personal items that people generally like to keep with them at all times. So I am tempted to say the search of the purse requires an intrusion so similar to a search of one's person that the same rule should govern both. However, given this court's prior cases, I give up. I cannot argue that the fact that the container was a purse automatically makes a legal difference, for the court has warned against trying to make that kind of distinction. But I can say that it would matter if a woman's purse, like a man's billfold, were attached to her person. It might then amount to a kind of outer clothing, which under the court cases would properly receive increased protection. In this case, the purse was separate from the person, and no one has claimed that under those circumstances the type of container makes a difference. For that reason, I join the court's opinion. Okay, Stephen Sauter Ginsburg dissent. In all of our prior cases applying the automobile exception to the Fourth Amendment's warrant requirement, either the defendant was the operator of the vehicle and in custody of the object of the search, or no question was raised as to the defendant's ownership or custody. In the only automobile case confronting the search of a passenger defendant, United States v. D. the court held that the search of a passenger defendant, U.S. v. D. the court held that the exception to the warrant requirement did not apply. In D. as here, the information prompting the search directly implicated the driver, not the passenger. Today, instead of adhering to the settled distinction between drivers and passengers, the court fashions a new rule that is based on a distinction between property contained in clothing worn by a passenger and property contained in passenger's briefcase or purse. In cases on both sides of the court newly minted test, the property is in a container, whether a pocket or a pouch, located in the vehicle. Moreover, unlike the court, I think it quite plain that the search of a passenger's purse or briefcase involves an intrusion on privacy that may be just as serious as was intrusion in D. Even apart from D. The court's rights restrictive approach is not dictated by precedent. For example, in the United States v. Ross, we were concerned with the interest of the driver in the integrity of his automobile, and we categorically rejected the notion that the scope of the warrantless search of the vehicle might be defined by the nature of the container by which the contraband is secreted. Rather, it is defined by the object of the search and the places in which there is probable cause to believe that it may be found. We thus disapproved of the possible container-based distinction between a man's pocket and a woman's pocketbook. Ironically, while we concluded in Ross that probable cause to believe that a container placed in the trunk of a taxi contains contraband or evidence does not permit a warrantless search of a passenger's briefcase in which it's probable cause to believe the taxi driver had a syringe somewhere in his vehicle. Nor am I persuaded that the mere spatial association between a passenger and a driver provides an acceptable basis for presuming that there are partners in partners in crime for ignoring privacy interests in a purse. Whether or not the Fourth Amendment required a warrant to search Houghton's purse, at the very least, the trooper in this case had to have probable cause to believe that her purse contained contraband. The Wyoming Supreme Court concluded that he did not. Finally, in my view, the state's legitimate interest in effective law enforcement does not outweigh the privacy concerns at issue. I am confident in the police officer's ability to apply a rule requiring a warrant or individualized probable cause to search belongings that are, in this case, obviously owned by and in custody of a passenger, as is the court in Passenger Confederates' ability to circumvent the rule. Certainly, the ostensible clarity of the court's rule is attractive, but that virtue is insufficient justification for its adoption. Moreover, a rule requiring a warrant or individualized probable cause to search passengers' belongings is every bit as simple as the court's rule. It simply protects more privacy. I would decide this case in accordance with what we have said about passengers and privacy, rather than what we have said in cases where the issue was not squarely presented. What Justice Jackson wrote for the court 50 years ago is as sound today. The government says it would not contend that armed with a search warrant for residents only, it could search all persons found in it, but person quite as readily as the canned occupant of a car. Necessary and argument advanced in support of this search would seem as strong as reason for searching guests of a house for which a search warrant had so by a parity of reasoning with that on which the government disclaims the right to search occupants of a house, we suppose the government would not contend that if it had a valid search warrant for the car only, it could search the occupants as an incident to its execution. How then could we say that the right to search a car without a warrant confers greater latitude to search occupants than a search by warrant would permit? We see no grounds for expanding the rule in Carroll just to justify this arrest and search is incident to the search of a car. We are not convinced that a person, by mere presence in a suspected car, loses immunities from search of his person to which he would otherwise be entitled. D. Ree. That's a quote from D. Ree. And instead of applying ordinary Fourth Amendment principles to this case, the majority extends the automobile warrant exception to allow searches of passenger belongings based on the driver's misconduct. Thankfully, the court's automobile analysis limits the scope of its holding, but it does not justify the outcome of this case.